The envelope arrived on a Tuesday morning in March. Sarah Whitmore stood in her kitchen in Portland, Oregon, holding a piece of paper that shouldn't exist. Her hands were shaking not from cold, but from the realization that everything settled 6 months ago was about to unravel. The document was dated August 2019, 3 years after her father's official will. 3 years after the family had already divided his estate, signed the papers, and tried to move on with their fractured relationships. This second will named different beneficiaries, different amounts, different intentions, entirely. Sarah's younger brother Michael received a call at his office in Seattle 30 minutes later. He listened without speaking, then quietly closed his laptop and told his assistant to cancel his afternoon meetings. His voice, according to those who were there, was completely flat. Their older sister Jennifer was the last to know. She was at a parent-teacher conference when Sarah's text came through. She read it twice, excused herself from the room, and sat in her car in the school parking lot for 40 minutes before driving home. The question that would consume the next year of their lives was simple. Which will was real? But the answer would force them to confront something far more disturbing, that they never really knew their father at all. Let me take you back to where this actually began. November 2021. Robert Whitmore died of a heart attack at age 73 in his home in Eugene, Oregon. He was found by his housekeeper on a Sunday morning, slumped in his leather armchair with a book on his lap and a glass of scotch on the side table. The medical examiner estimated he'd been dead for approximately 6 hours. Robert had been a successful commercial real estate developer, not wealthy by billionaire standards, but comfortable, very comfortable. His estate was valued at approximately $4.2 million. This included his primary residence, valued at $850,000, a vacation property in Bend worth $600,000, various investment accounts totaling $2.1 million, and a small commercial building in downtown Eugene that generated rental income, valued at approximately $750,000. He had 3 children from his marriage to Linda Witt, who had died of cancer in 2008. Sarah was 41, a high school guidance counselor. Michael was 39, a software project manager. Jennifer was 44, a stay-at-home mother of 3 who had left her nursing career 15 years earlier. The family gathered for the funeral on a cold, gray November afternoon. Approximately 60 people attended. Friends from the Rotary Club, former business associates, a few distant cousins. The service was respectful and brief. Robert hadn't been particularly religious, and the pastor who officiated had only met him twice. What struck several attendees was the distance between the siblings. They sat in the front row with space between them. They didn't embrace. When people offered condolences, each responded politely but separately, as if they were strangers who happened to share a last name. The will reading took place 1 week later at the law offices of Patterson and Burke in downtown Eugene. The attorney, Gerald Patterson, had been Robert's lawyer for 18 years. He was 67, methodical, and known for his careful documentation. The will was dated June 2016, 5 years before Robert's death. It had been properly witnessed, notarized, and stored in Patterson's office safe. There was no ambiguity about its authenticity. The distribution was straightforward. Sarah received 40% of the estate, approximately $1.68 million. Michael received 40% as well. Jennifer received 20%, roughly $840,000. The reasoning became clear when Patterson read a specific clause Robert had included. Jennifer had received a substantial gift, years earlier $320,000 in 2014, to help with her children's education and to purchase a larger home. Robert stated in the will that this advance should be considered when calculating final distributions. Jennifer sat very still during the reading. Her husband Mark placed his hand on her arm, but she didn't respond. Her face revealed nothing. Sarah, who had expected an equal split, tried to hide her surprise at receiving more. Michael showed no reaction at all. The vacation property in Bend went to Sarah and Michael jointly. The commercial building would be sold, with proceeds divided according to the percentage allocations. The primary residence would also be sold unless one of them wished to purchase it at market value using their share of the inheritance. Patterson asked if there were any questions. There were none. He distributed copies of the will and supporting documents. The meeting lasted 27 minutes. They signed the necessary papers over the following weeks. An estate sale was organized for Robert's personal belongings. The house was listed in January 2022. It sold in February for $895,000, $45,000 above asking price. By March 2022, the estate was largely settled. Checks were distributed. Assets were transferred. The siblings had minimal contact during this process, communicating primarily through Patterson's office. Sarah remembered later that she felt relieved when it was finished. Not happy her father was dead, but relieved that it was done without any major conflict. Michael told a friend at the time that he was surprised how smoothly everything had gone, given their family history. Jennifer said nothing to anyone about how she felt, but something wasn't right. In early April, Jennifer received a call from her father's former housekeeper, Maria Cordoba, who had worked for Robert for 11 years. Maria was calling to ask about some boxers she'd found in the garage while helping clear out the last items from the house before the new owners took possession. Most of it was junk, Maria explained. Old tax returns, expired insurance policies, receipts from the 1990s. But there was one box sealed with packing tape, labeled simply Personal minus 2019 in Robert's handwriting. Jennifer asked Maria to drop it off. Maria brought it to Jennifer's house in Springfield that evening. Jennifer thanked her, paid her the remaining balance owed for her help, and placed the box in her garage without opening it. She would later struggle to explain why she waited 3 weeks before looking inside. Maybe she wasn't ready. Maybe she was afraid of what she'd find. Maybe she was just busy with her kids and forgot about it. But on a Saturday afternoon in late April, while her husband took their children to soccer practice, Jennifer finally opened the box. Inside were documents, personal letters, photographs, bank statements, and, at the very bottom, wrapped in a manila folder, a document labeled Last Will and Testament of Robert James Whitmore, dated August 12, 2019. Jennifer read it sitting on the concrete floor of her garage. Then she read it again. Then she called her husband and told him to come home immediately. Something was very wrong. The second will divided the estate equally, 33.3% to each child. No mention of the previous advance to Jennifer. No special allocation. And, most disturbingly, a handwritten note attached to the document explaining that Robert had changed his mind about the earlier will because he felt, quote, circumstances had changed regarding fairness and my understanding of each child's needs and contributions. The will was signed, witnessed by 2 people Jennifer didn't recognize, Daya Morales and Thomas June, notarized by a notary public named Catherine Brennan in Portland, Oregon. Jennifer contacted Sarah first. Sarah drove to Jennifer's house that evening. They sat at the kitchen table and examined every page. Sarah noticed immediately that the witnesses were not the same people who had witnessed the 2016 will. She also noticed that the notary was in Portland, over 100 miles from Eugene, where Robert had lived and where his attorney was based. The question neither of them could answer was simple. Why would their father create a second will with a different attorney or notary, never mention it, and hide it in a sealed box in his garage? Michael arrived an hour later. He studied the document in silence for several minutes, then looked up at his sisters with an expression they both described later as unreadable, not angry, not surprised, just utterly blank. This doesn't make sense, he said. Why wouldn't he tell Patterson? Why wouldn't he destroy the old will if he'd changed his mind? Sarah pointed out what all of them were thinking, but none had said aloud. If this will was valid, it meant Michael and Sarah would each have to return approximately $280,000 to the estate for redistribution. Jennifer would receive an additional $560,000. The money created an obvious problem, but there was something else. Something that made Sarah's stomach turn as she sat in her sister's kitchen that night. The note attached to the will used the phrase, each child's needs and contributions. What did that mean? What contributions? What needs? And why had their father felt the need to revise his careful legalism 2016? Well, with this mysterious document that no one knew about. Michael took photos of every page with his phone. Sarah made copies. On Jennifer's printer, they agreed to contact Gerald Pattison first thing Monday morning. None of them slept well that night. Act to the family mask. To understand what happened next, you need to understand what the Widmore family had been long before Robert died. From the outside, they looked like exactly what they were. An upper-middle-class American family. Robert had built his real estate business slowly and carefully over 30 years. Linda had been a devoted mother and community volunteer. The children had grown up in a comfortable 4-bedroom house with a pool, taken family vacations to Disneyland and later Europe, attended good schools. But families are never just what they appear to be. Sarah, the middle child, had always been the responsible one. Strata, student, full scholarship to the University of Oregon. Master's degree in counseling. She'd married at 28 to a man named David Chun, a pharmacist. They had one daughter, Emily, now 14. Sarah's life looked stable, even admirable. What people didn't see was the credit card due to approximately $47,000 during her mother's illness, when Sarah had taken unpaid leave to help with care and funeral arrangements. David's pharmacy had faced intense competition from chain stores, and his income had dropped significantly. They were managing, barely, but the inheritance had felt like oxygen. Michael, the youngest, was harder to read, highly intelligent, introverted, and intensely private. He'd moved to Seattle for work at 26, and rarely came back except for major holidays and, eventually, funerals. He'd never married. His Seattle condo was paid off. He'd bought it in 2010 when prices were lower end. His tech job paid him $135,000 annually. He didn't need the inheritance money, but he'd immediately placed his share in index funds and never spoke about it. Several family members described him as emotionally detached. Others said he was just careful. A cousin who'd known him since childhood used a different word. Wounded. Jennifer, the eldest, had given up the most. She'd been a talented student, graduated with honors from nursing school, worked in labor and delivery for 6 years. Then she'd met Mark Thompson, married at 27, and had 3 children in quick succession. The choice to stay home had been partially financial childcare costs and partially personal. Mark worked in insurance sales with an inconsistent income that ranged from $60,000 to $90,000 depending on the year. They lived in a modest house in Springfield that was aging poorly, roof problems, foundation cracks. The money Robert gave them in 2014 had indeed gone toward a larger home and education accounts. But what Jennifer never told anyone was that $20,000 of it had also gone to paying off Mark's gambling debts. Mark had promised to stop. He did, mostly. The damage to their finances remained. The siblings' relationships with each other had deteriorated slowly over decades, like rust. Sarah and Jennifer had been close as children, but distance grew after their mother's death. Jennifer resented that Sarah lived only 30 minutes from their father, but visited infrequently. Sarah resented that Jennifer seemed to expect everyone to accommodate her schedule because she had children, as if Sarah's teaching job and her own daughter didn't matter. Michael had been close to no one since high school. He called dutifully on birthdays and holidays. He sent thoughtful gifts, but he never revealed anything personal, never asked for help, never seemed to need anyone. Linda had worried about him before she died, telling Sarah once that Michael carried something heavy inside him that he wouldn't share. And their relationships with Robert, that was more complicated still. Robert had been a pragmatic man, fair, usually, but emotionally reserved. He showed love through actions, paying for college, helping with down payments, arriving to fix a broken water heater. Conversations about feelings made him visibly uncomfortable. After Linda died, he retreated further into his routine work, Rotary Club meetings, reading, scotch in the evening. Sarah had tried to maintain a relationship with him. Sunday dinners once a month. Phone calls every week. She felt it was her duty as the geographically closest child, but Robert was difficult to talk to. He asked surface questions about Emily's grades and David's work, nodded, and then changed the subject or turned on the television. Sarah often left these visits feeling more alone than before she arrived. Jennifer had a different relationship with him. She needed him more visibly, for advice about her kids, for validation that staying home had been the right choice. Robert helped, but there was always a subtle quid pro quo. He'd write a check, then mention how he wished she visited more often. He'd praise her children, then ask why Mark's career wasn't more stable. Jennifer learned to accept the help and ignore the commentary, but it wore on her. Micah barely had a relationship with Robert at all after moving to Seattle. They spoke perhaps 4 times per year. Conversations lasted under 10 minutes. Robert once told a friend he didn't understand his son, that Michael had closed himself off and he didn't know why. What none of the siblings knew was that their father had been keeping detailed notes. In his home office, in a locked drawer of his desk, Robert had maintained a journal. Nothing flowery or emotional, just observations, records of conversations, concerns. Gerald Patterson would later describe it as disturbingly analytical, almost like a case file on his own children. Maria, the housekeeper, had seen him writing in it occasionally. She'd assumed it was business notes or financial planning. She'd never asked. Robert never explained. After the discovery of the second will, Patterson searched Robert's remaining files at his office. The journal wasn't there. It had likely been in the house, possibly in that sealed box, possibly somewhere else entirely. Either it had been thrown away during the estate sale, or someone had taken it without realizing its significance. But fragments of Robert's thinking would emerge through other documents, emails, letters, notes, in margins of financial records. One email to Patterson from July 2018, discussing estate planning generally, included this line: "I've been reconsidering fairness. Equal isn't always equitable. Need to think about who has been present versus who has been absent, who has needed help versus who has managed independently." Another note, found in a folder about the commercial property, written in Robert's handwriting. "Michael doesn't need it. Sarah needed it and used it well. Jennifer needed it and still struggles. What's my responsibility here?" A third document, dated January 2019, was more direct. A letter addressed to no one, apparently never sent. "I gave Jennifer money in good faith. Mark gambled portions of it away. She never told me. I found out through overheard conversations. Do I punish her for his mistakes, or do I hold her accountable for choosing a partner poorly?" These documents would surface slowly over the coming months, each one adding layers to a picture. None of the children wanted to see that their father had been watching them, judging them, and making calculations about their worth. On Monday morning, April 29th, Sarah called Gerald Patterson's office and scheduled an emergency meeting. Patterson agreed to see all 3 siblings that afternoon. They gathered in the same conference room where the original will had been read 5 months earlier. Patterson examined the second will carefully. He compared signatures. He checked the notary seal. He read every clause twice. Then he said something that would change everything. "This appears to be legitimate." Sarah felt the room tilt. Michael's jaw tightened. Jennifer, who'd expected validation, instead felt a wave of dread. Patterson explained that the signature matched Robert's signature on file. The notary seal appeared genuine. The witnesses had signed appropriately. The language was legally sound, if less sophisticated than the 2016 will. And critically, it was dated 3 years later, which in probate law generally means it supersedes the earlier will. "But why didn't he tell you?" Sarah asked. "You were his attorney for 18 years. Patterson had no answer to that. He'd ask himself the same question all morning after Sarah's call. "It's not illegal to create a will without your regular attorney," Patterson said. "People do it all the time. Online services, legal aid clinics, other attorneys." But Robert was meticulous. This doesn't fit his character. Michael asked the question none of them wanted to hear. "So what happens now?" Patterson explained the process. They would need to file the second will with the probate court. There would be a hearing to determine its validity. The court would examine the document, possibly contact the witnesses and notary, and make a ruling. If the 2019 will was deemed valid, the estate would need to be redistributed according to its terms. That means Sarah and I pay back money we've already spent or invested, Michael said. Potentially, yes. Patterson confirmed. The meeting lasted an hour and 40 minutes. Patterson agreed to handle the filing and represent the estate through the probate challenge. He made it clear that his role was neutrally represented the estate and Robert's wishes, not any individual siblings' interests. As they stood to leave, Jennifer asked one more question. What if one of us contests it? Patterson looked at her carefully. You can contest. You need to prove either that the document is fraudulent, that Robert lacked mental capacity when he signed it, that he was under undue influence, or that it fails to meet legal requirements. Given that this is dated 2019, and Robert lived until 2021 with no signs of cognitive decline, and given that the document appears properly executed, that would be a difficult case to make. They walked out into the parking lot in silence. Sarah got into her car without saying goodbye. Michael stood by his vehicle for a moment, then turned to Jennifer. Did you know about this? He asked. What? No. Of course not. But you found it. In Dad's garage, in a box. I had no idea it existed. Michael studied her face. You benefit from it. Significantly. I know how it looks, Genevieve sighed. But I didn't know. I swear to you, Michael, I didn't know. He nodded slowly, but something in his expression suggested he wasn't entirely convinced. He got in his car and drove away. Jennifer stood alone in the parking lot, holding a folder of documents, and realized with absolute clarity that even if the second will gave her money, it was about to cost her what remained of her family. If you're drawn to stories like this family's unraveling over secrets and inheritance, this channel explores them regularly. Subscribing means you won't miss what comes next. The probate filing was submitted on May 3, 2022. The court scheduled a hearing for June 15. Sarah hired her own attorney, Ellen Friedman, a probate specialist in Portland. The decision to hire separate counsel created immediate tension. Jennifer interpreted it as Sarah preparing to fight the second will. Sarah insisted she just wanted independent advice. Michael did not hire an attorney. When Sarah asked him why, he said he'd wait to see what the court decided. The 6 weeks between filing and hearing were marked by silence and suspicion. Sarah tried to reach out to Jennifer twice. Both conversations were brief and tense. Jennifer insisted she'd done nothing wrong. Sarah said she wasn't accusing anyone. She just wanted to understand. But everything they said to each other felt like a cross-examination. Michael didn't respond to messages from either sister. Behind the scenes, attorneys were working. Patterson's office contacted the notary, Catherine Brennan, in Portland. Brennan confirmed that she had notarized a document for Robert Whitmore on August 12, 2019, at a FedEx office location on Northwest 23rd Avenue in Portland. Her records showed Robert had presented valid identification, signed a document in her presence, and appeared to be of sound mind. She remembered him. Faglia, an older gentleman, polite, had made an appointment specifically for the notarization. The witnesses were tracked down next. Diane Morales was a retired teacher living in Portland. Thomas June was an accountant, also in Portland. Both confirmed they had witnessed Robert sign the document on the same date at the same FedEx office location. They had been customers in the store at the time. Robert had asked if they would serve as witnesses, explained it was for a will, and offered them each $20 for their time. They had watched him sign, then signed themselves, and never saw him again. This information was compiled in a report submitted to the court. On its face, the process was completely legitimate. But Sarah's attorney raised several questions in a written brief to the court. 1. Why would Robert drive over 100 miles to Portland to have a will notarized when he had an attorney in Eugene? 2. Why would he use random strangers as witnesses instead of people who knew him? 3. Why would he hide the document instead of filing it with Patterson or keeping it in an accessible location? 4. Why would he not destroy or revoke the 2016 will if he truly intended for the 2019 will to supersede it? 5. If he wanted to change his estate plan, why not simply update through proper channels with his attorney of record? The brief didn't accuse anyone of forgery or fraud. It simply argued that the circumstances were suspicious enough to warrant extreme scrutiny. Jennifer's husband, Mark, became involved for the first time in mid-May. He contacted a litigation attorney named Raymond Pierce without telling Jennifer initially. Pierce advised that if Jennifer was accused of any wrongdoing, fraud, manipulation, knowledge of the will's existence before it was convenient to reveal, she should be prepared to defend herself aggressively. When Jennifer found out Mark had hired Pierce, they had their worst argument in years. Jennifer didn't want to appear combative. Mark insisted she needed protection. Their 16-year-old daughter, Ashley, overheard the fight and later told the school counselor she was worried her parents might divorce. That information never reached Jennifer or Mark, but it reflected the toll the situation was taking on the entire family. The court hearing on June 15th was held in Lane County Circuit Court. Judge Margaret Holloway presided. She had 23 years of experience in probate cases and a reputation for all three siblings attended. Sarah with her attorney, Jennifer with Mark, and now attorney Raymond Pierce. Michael alone. Patterson presented the facts. 2 wills existed. Both appeared legally valid. The second was dated later. Under Oregon law, a later will generally supersede an earlier one, unless the testator explicitly states otherwise, or unless evidence suggests incapacity, fraud, or improper execution. Judge Holloway asked if there was any evidence of fraud. Sarah's attorney presented the questions about Robert's behavior, but acknowledged there was no direct evidence of forgery or deception. Judge Holloway asked if there was any evidence of mental incapacity. Patterson stated that Robert had been in good physical and mental health in 2019, with no medical records indicating cognitive decline until his death in 2021. Judge Holloway asked if any party wished to contest the validity of the 2019 will. Sarah's attorney indicated Sarah had concerns, but was not prepared to file a formal contest. Without further investigation, Michael was asked directly if he had a position. He stated, "For the record, I think something isn't right here, but I don't know what it is. I'd like time to understand before making a decision." The judge reviewed both wills again. She questioned Patterson about his knowledge of Robert's intentions. Patterson testified that Robert had never mentioned creating a second will, had never indicated dissatisfaction with the 2016 will, and had never requested any changes to estate planning documents after 2016. After 90 minutes, Judge Holloway announced her preliminary finding. Both documents appear facially valid. The 2019 will was properly executed according to Oregon statute. However, the circumstances raised by counsel are notable. I'm going to order a 30-day investigation period. I want the notary and witnesses were interviewed under oath. I want a complete financial analysis to determine if any party stood to gain from concealing or revealing either will. And I want a handwriting expert to compare the signature on the 2019 will against known samples of Mr. Whitmore's signature. She continued, if, after 30 days, there remains no evidence of fraud, incapacity, or improper execution, I will likely rule that the 2019 will is valid and order redistribution of the estate accordingly. However, I am also ordering that all parties refrain from spending or transferring any additional inherited assets until this matter is resolved. The hearing concluded. The siblings left without speaking to each other. Sarah drove back to Portland, feeling vindicated that the judge had concerns. Jennifer drove back to Springfield, feeling like she was under investigation for a crime she didn't commit. Michael drove back to Seattle and immediately requested a week of vacation from his job. What none of them knew yet was that the 30-day investigation would uncover far more than signature verification. It would reveal that their father had lived a double life they never suspected, and that the inheritance was only the beginning of what had been hidden. Act 3. The fracture the handwriting analysis came back first. Dr. Leonard Shaw, a forensic document examiner with 30 years of experience, compared the signature on the 2019 will against 15 known examples of Robert Whitmore's signature from various documents between 2015 and 2021. Tax returns, property deeds, bank records, letters. His conclusion, delivered in a 12-page report. The signature was consistent with Robert Whitmore's signature, showing natural variation expected from documents signed at different times and under different circumstances. There were no indicators of forgery, tremor, or simulation. The 2019 will was signed by Robert Whitmore. Sarah received this news from her attorney on June 29th. She sat at her kitchen table and cried. David found her there 20 minutes later and didn't know what to say. The signature was real. That meant her father had intentionally created this second will and hidden it. But why? The notary and witnesses were re-interviewed under oath on July 5th by a court-appointed investigator named Thomas Brighton. Brighton was a retired FBI agent who now worked as a private investigator for the court system. Catherine Brennan, the notary, was interviewed first. She repeated her earlier statement. Robert Whitmore appeared on August 12, 2019, with a pre-prepared document. He had valida. He signed in her presence. He appeared completely mentally competent. She had no reason to question the legitimacy of the transaction. Brighton asked if Robert seemed nervous or under duress. Brennan said no. He seemed calm, businesslike. She processed dozens of notarizations per week. Robert was unremarkable except that he was polite and tipped her $10. Diane Morales, the first witness, provided similar testimony. Robert approached her in the FedEx office, explained he needed witnesses for a will, and asked if she'd help. She agreed. She watched him sign. She signed herself. Transaction completed. Robert thanked her, paid her $20 cash, and left. The entire interaction lasted less than 5 minutes. Thomas Chun, the second witness, told the same story. He'd been making copies for his accounting firm. Robert asked. He agreed. He signed. Robert paid him. Done. Brighton's report noted that all three individuals were credible, their stories consistent, and there was no indication any of them had prior relationships with Robert or any of the siblings. The financial analysis took longer. Patricia Valdez, a forensic accountant hired by the court, spent 3 weeks examining financial records for Robert and all three siblings. Her mandate was to determine if anyone had motive or opportunity to fabricate, conceal, or reveal, either will strategically. Her findings were detailed in a 28-page report submitted to the court on July 18th. Robert's finances were clean. No unusual transactions, no large withdrawals or transfers before his death, no payments to attorneys other than Patterson, no evidence of financial pressure or manipulation. Sarah's finances showed the credit card debt and her immediate use of inheritance funds. To pay it off, she'd placed the remaining funds in a high-yield savings account. Nothing suspicious. Michael's finances showed exactly what would be expected. Inheritance deposited, immediately invested in index funds. No subsequent activity. His personal accounts showed consistent income and minimal expenses. No red flags. Jennifer's finances were more complicated. In March 2022, 1 month before the second will was discovered, Mark Thompson had won $7,400 on a sports betting app. He deposited the money into their joint checking account, then immediately transferred $6,000 to an account at a different bank that Jennifer didn't regularly access. In April, after the second will was found, but before the probate filing, Jennifer had transferred $15,000 from her inheritance into a separate savings account under only her name. Then, on May 10th, Jennifer had consulted with Raymond Pierce, the attorney, and paid him a $5,000 retainer using money from the inheritance. Valdez's report didn't accuse Jennifer of wrongdoing, but it noted that Jennifer's financial behavior showed more activity and more strategic movement of funds than her siblings. Sarah's attorney obtained a copy of this report through discovery. When Sarah read it, she called Michael for the first time in weeks. "Did you see the financial report?" she asked. "I saw it. The part about Jennifer moving money around, I saw it. What do you think?" There was a long pause. Then Michael said something that surprised Sarah. "I think we need to talk to Maria, the housekeeper. She was there twice a week for 11 years. If anyone knows what was really going on in that house, it's her." Sarah met Michael and Maria Cordova at a coffee shop in Eugene on July 22nd. Maria was 61, originally from Mexico, and had been genuinely fond of Robert despite his emotional distance. They assured her she wasn't in trouble. They just wanted to understand their father better. Maria was hesitant at first. She respected people's privacy. But eventually, she began to talk. Robert had been lonely after Linda died, she said. He filled his days with routine, work, reading, television. He drank more than was probably healthy, but never in a sloppy way, just methodical consumption every evening. He'd talk to Maria sometimes while she cleaned, not deeply, but in fragments, about his children, about his regrets. He said you were the good one, Maria told Sarah. He thought you tried with him, but he also said you didn't really understand him. She turned to Michael. He worried about. He said you were angry about something but wouldn't talk about it. He didn't know how to reach you. And Jennifer. Maria's expression changed. Jennifer, he felt sorry for, Maria said, but also frustrated with. He helped her so much over the years, but it was never enough. Her husband had problems. Money. Problems. Gambling. Your father knew. He told me once that he'd enabled Jennifer's choices by always bailing her out, and he didn't know if helping more would make it better or worse. Sarah asked if Robert had ever mentioned changing his will. Maria thought carefully. Not directly. But in 2019, spring or summer, he was stressed about something. He made several trips to Portland. He didn't usually go to Portland. When I asked if everything was okay, decided he was taking care of some things that should have been handled differently the first time. I didn't know what he meant. Michael leaned forward. Did he go to Portland alone? As far as I know, yes. Did anyone visit him during that time? Anyone unusual? Maria considered this. There was a woman, early 50s, maybe. She came to the house twice in 2019, maybe June or July. They talked in his office with the door closed. I don't know who she was. I assumed she was a business associate. Sarah and Michael exchanged glances. Robert's business dealings were well documented. Patterson had reviewed them thoroughly during estate settlement. There was no record of any female business associate from that period. Can you describe it? Sarah. Asked. Professional looking. Dark hair. Nice clothes. She drove a silver car. Maybe a Honda or Toyota. I'm not sure. They thanked Maria and paid for a coffee in time. As they walked to their cars, Michael said what they were both thinking. Who was the woman? Sarah had no answer, but she immediately called her attorney and relayed the information. Ellen Friedman, Sarah's attorney, hired her own investigator, a woman named Rachel Kim, to look into Robert's activities in 2019. Kim was thorough and discreet. Within a week, she'd found something. Robert had rented a safe deposit box at a U.S. bank branch in downtown Portland in April 2019. The rental agreement was in his name only. He'd accessed the box 4 times between April and October 2019. The last access was October 9th, 2019, less than 3 weeks before he died in November 2021. Wait, that timeline didn't make sense. Rachel Kim, no. The dates were correct. He'd rented the box in April 2019, accessed it periodically through October 2019. But then the bank had no record of any additional access until his death. Kim obtained a court order to access the box. On August 2nd, 2022, accompanied by Patterson and a bank officer, the box was opened. Inside were documents, letters, photographs, and a letter addressed to my children, to be opened only if certain things come to light. The letter was dated October 1st, 2019. Patterson opened it with trembling hands. It read, Sarah, Michael, and Jennifer. If you're reading this, it means someone has found the will I created in August. I hoped it wouldn't be necessary to explain, but I realize I may owe you clarity. I've spent the last 2 years questioning my decisions about fairness. When I created the 2016 will, I believed I was being fair by accounting for the money I'd given Jennifer earlier. But fairness is more complicated than math. In 2018, I learned that Mark gambled away a portion of what I gave Jennifer. She didn't tell me. I found out through his brother, who asked me if I was aware of the situation. I was disappointed, but I realized Jennifer was trapped in something she couldn't control. I also realized that I'd been unfair to all of you in different ways. I gave Jennifer money, but judged her for needing it. I praised Sarah for independence, but didn't recognize how much she struggled. I left Michael alone because he seemed fine, never asking if that's what he wanted. I wanted to start over, split things equally. But I knew if I did it officially through Gerald, you would ask questions, and I'd have to explain, and I wasn't ready for those conversations. So I made a new will, quietly. I intended to file it officially before my death and destroy the old one, but I couldn't bring myself to do it. Not because I changed my mind about the distribution, but because filing it felt like admitting I'd gotten it wrong the first time. I know this is cowardice. I'm sorry for that. If this will has been found and filed, I hope you'll understand that my final intention was equality. Not because you're equal in your choices or needs, but because you're equally my children, and I failed all of you in ways I'm only now beginning to understand. The woman some of you may have learned about is named Caroline Porter. She's a mediator who helped me think through these questions. She has no financial interest in any of this. She was simply someone outside the family who listened. I'm sorry for the confusion this will cause. I'm sorry I wasn't brave enough to do this properly. Dad Sarah read the letter 3 times. Michael read it once, then handed it back to Pedersen. Without expression. Jennifer, who received a copy by email an hour later, read it and then sat in her parked car outside her daughter's school and sobbed. The letter explained everything and nothing. It explained why Robert had created the second will. It explained the trips to Portland. It explained his secrecy, but it didn't explain why he'd never filed it. It didn't explain why he'd kept both wills in existence. It didn't resolve the fundamental question. What did Robert actually want? Sarah's attorney filed a supplemental brief with the court, arguing that Robert's letter demonstrated ambivalence, and that the 2016 will executed through proper legal channels with his attorney of record should stand as his true final intent. Jennifer's attorney filed a counterbrief arguing that Robert's letter clearly stated his final intention was equality and that the 2019 will reflected his mature, considered judgment. Judge Holloway scheduled a second hearing for August 25th, but before that hearing could take place, something else emerged. On August 15th, Michael received an email from an address he didn't recognize, cp.or.mediation@gmail.com. The subject line read, "Information about your father." The email was brief. "Mr. Whitmore, my name is Caroline Porter. Your father mentioned me in his letter. I saw the news coverage of your probate case and felt I should reach out. Your father and I spoke extensively in 2019. There are things he told me that you deserve to know, but that he asked me never to reveal unless absolutely necessary. I believe we're at that point. If you're willing to meet, I can explain what your father was really trying to do and why he couldn't bring himself to complete it. Caroline Porter." Michael forwarded the email to Sarah with one word. "Thoughts." Sarah called him immediately. "Do we tell Jennifer?" "Not yet," Michael said. "Let's find out what this is first." They agreed to meet Caroline Porter together. She suggested a quiet restaurant in Portland on August 18th. Caroline Porter was 53, a licensed family mediator and therapist specializing in estate conflicts. She was professional, warm, and careful in her words. She ordered coffee and began. "Your father contacted me in March 2019 after reading an article I wrote about inheritance and family dynamics. He was struggling with how to divide his estate, not because of the money itself, but because of what it represented." Sarah asked what she meant. "He felt he'd failed all of you," Caroline explained. "He told me he'd been emotionally absent after your mother died, that he'd treated you more like problems to solve than people to know. He wanted to make amends, but he didn't know how." Michael's expression remained neutral, but his hands tightened on his coffee cup. Caroline continued, "We met 6 times between March and October 2019. We talked about each of you, about his regrets, about whether money could fix anything. He's particularly troubled about Jennifer. He'd enabled dysfunction by giving her money without boundaries, but he also felt guilty because he knew Mark's issues weren't her fault." "Did he tell you about the second will?" Sarah asked. Yes. He told me he'd created it in August. He was proud of himself for taking action. But almost immediately, he regretted it. Not the decision, he still wanted to split things equally, but the method. He realized that hiding it was the same pattern he'd always followed, avoiding difficult conversations. So why didn't he just file it officially? Michael asked, speaking for the first time. Carolyn met his eyes. Because he was afraid of you. The word hung in the air. Afraid of me, Michael repeated. Not physically. Emotionally. He told me that you were the child he understood least and heard most. He said something happened when you were younger that damaged your relationship, and he never addressed it, and now it was too late. Michael's face went completely still. Sarah stared at her brother. What is she talking about? Michael didn't answer. Caroline spoke gently. Your father told me about the college incident, about how he handled it. He said it was the worst mistake he ever made as a parent, and that you never forgave him, and he didn't blame you. Sarah looked between them, completely confused. What college incident? Michael stood up. I need to leave. Michael Sarah started. I'm done with this conversation. He walked out of the restaurant. Sarah turned to Caroline. What was she talking about? Caroline hesitated. I'm sorry. That's something Michael needs to tell you himself. Your father gave me permission to share what was necessary to explain the will situation. But that particular story is Michael's to share, not mine. Sarah left the restaurant more confused than when she'd arrived. She called Michael 7 times over the next 2 days. He didn't answer. Jennifer learned about the meeting with Caroline through a casual comment Sarah made on a family text thread, asking if anyone knew what happened with Michael in college. Jennifer responded immediately. What meeting? What are you talking about? When Jennifer found out that Sarah and Michael had met with Caroline Porter without telling her, the fragile truce between the sisters shattered completely. Jennifer called Sarah and unleashed months of accumulated frustration. You think I did something wrong? You think I hid that will? You're investigating me behind my back, meeting with mediators, checking my finances, treating me like a criminal. I found that will and reported it immediately. I could have burned it. I could have pretended it never existed, but I didn't, because I'm not a liar, which is apparently more than you think of me. Sarah tried to explain. We weren't investigating you. We were just trying to understand what Dad was thinking. By excluding me, by treating me like the suspicious one. I'm the one who needs the money. So obviously I must have done something wrong, right? The call ended badly. Jennifer blocked Sarah's number. Mark, watching his wife spiral, became convinced that Sarah and Michael were conspiring to contest the will specifically to hurt Jennifer. He contacted Raymond Pierce and asked what legal options they had if the other siblings were acting in bad faith. Pierce advised caution, but Mark didn't listen. He drafted an email to Michael, accusing him of coordinated harassment and threatened legal action if Michael didn't publicly commit to accepting the 2019 will. Michael's response was one sentence. I don't respond to threats. The family was now in open warfare, and none of them knew yet that the real secrets hadn't been revealed at all. Act 4. The hidden past the college incident emerged piece by piece, like fragments of a shattered mirror. Sarah, desperate to understand, finally called someone she hadn't spoken to in years, Dr. Helen Morris, who had been the Dean of Students at the University of Oregon when Michael was a student there from 2002 to 2006. Dr. Morris, now retired, remembered Michael immediately. Brilliant student, she said. Quiet. Very private. And yes, there was an incident. I can't give you details because of privacy regulations, but I can tell you it was serious. It involved another student, and the way his father handled it caused significant harm. Sarah pressed for more. Dr. Morris said only, your brother needed support, and he didn't get it from the person who mattered most. That's all I can say. Sarah went through old family photos and correspondence. She found something she'd forgotten. In spring 2005, Michael had come home for several weeks in the middle of the semester. Their mother had said he was stressed and needed a break. He'd stayed in his room mostly, barely eating. Then he'd gone back to school, and never mentioned it again. Sarah had been finishing her master's degree at the time, consumed with her own life. She hadn't asked questions. She contacted Michael one more time, via email, because he still wasn't answering calls. I don't know what happened in 2005, but I'm your sister, and whatever it was, I should have been there. I'm sorry I wasn't. If you're willing to tell me now, I'm willing to listen. Michael responded 2 days later. It doesn't matter anymore. Leave it alone. But Sarah couldn't leave it alone. She drove to Seattle, unannounced, on August 23rd, 2 days before the scheduled court hearing. Michael answered his condo door in sweatpants and a t-shirt. He looked exhausted. You can't just show up here, he said. I did, though. Can I come in? He hesitated, then stepped aside. His condo was immaculate. Minimalist furniture, everything in its place. It felt less like a home and more like a well-organized storage unit. They sat in his living room. Sarah waited. Finally, Michael spoke. Spring semester, 2005, I was a junior. I had a roommate named Eric. We were close, really close. I thought we were in a relationship. Turns out, he didn't see it that way. When I told him how I felt, he reacted badly. He told other people. It became a thing. There was an incident at a party. He got drunk, said some things, shoved me. Campus security got involved. Sarah listened, her heart sinking. Dad came down to deal with it. Michael continued. I told him everything. I told him I was gay. I told him I'd thought. Erica and I were together. I told him I was humiliated and didn't know what to do. What did Dad say? Michael's laugh was bitter. He said I should have been more discreet. He said I'd misread social signals and put myself in an uncomfortable position. He said the best thing to do was keep my head down, finish the semester, and be more careful about these things in the future. He never once asked if I was okay. He never once said it wasn't my fault. He treated it like a PR problem he had to manage. Sarah felt tears on her face. Michael, I'm so sorry. I stopped talking to him about anything real after that. I finished school. I moved to Seattle. I built a life where I didn't need him. And I was fine with that. I didn't want his money or his approval or his regrets. But he left you money anyway. He did. And then he apparently felt guilty about it and created a secret will to fix his guilt, which solved nothing and hurt everyone. That's who Dad was. He made decisions, regretted them, but never actually faced the consequences or had the hard conversations. Sarah asked carefully, do you care about the money? About which will stands? Michael thought for a long time. No, I genuinely don't. What I care about is that he did this to us. He knew the wills would create conflict. He knew we'd fight. And he did it anyway because he was too cowardly to make a clear choice. They sat in silence. Finally, Sarah said, the hearing is in 2 days. What do we do? I don't know, Michael said, but I'm done protecting Dad's reputation. If this goes to court, I'm telling the truth about what kind of father he was. Jennifer knew none of this conversation had happened. She showed up at the August 25th hearing believing her siblings were united against her. Judge Holloway took the bench at 2 p.m. The courtroom was nearly empty except for the parties, their attorneys, and Patterson. The judge reviewed the submitted documents, the 2 wills, the handwriting analysis, the financial report, Robert's letter, and various affidavits. She asked if any party had additional evidence to present. Michael stood. His attorney hadn't prepared a statement, so he spoke on his own behalf. Your Honor, I'd like to provide context about my father's character and decision-making that's relevant to understanding his intentions. Judge Holloway allowed him to proceed. Michael spoke for 12 minutes. He described Robert's emotional distance, his pattern of avoiding difficult conversations, his tendency to make decisions and then regret them without correcting course. He described, briefly and without excess detail, the college incident and Robert's failure to support him. My father didn't fail to file the 2019 will because he changed his mind about its contents, Michael said. He failed to file it because filing it would have required him to admit the 2016 will was wrong, and that would have required him to admit he'd failed us. He couldn't do that. So we created this impossible situation where both wills existed, and we'd be left to figure it out. Jennifer's attorney objected that this was speculation about intent. Judge Holloway overruled. It's testimony about the decedent's character, which is relevant to interpreting ambiguous testamentary actions. Continue, Mr. Whitmore. I don't think either will represents what my father really wanted, Michael said. What he wanted was for us to forgive him, without him having to ask for forgiveness. He wanted to fix things without doing the work of actually fixing them. The wills are both evidence of that same pattern. He sat down. Judge Holloway looked at Jennifer. Miss Thompson. Do you wish to respond? Jennifer's attorney advised her not to speak, but Jennifer stood anyway. I didn't know any of this, she said, her voice shaking. I didn't know what happened to Michael. I didn't know Dad had treated him that way. I'm so sorry, Michael. I really am. She turned to the judge. I also didn't know about the gambling problem being worse than I'd admitted to my father. He was right that Mark gambled away some of the money. I was embarrassed. I didn't want to admit I'd married someone who couldn't get control of that. My father helped me anyway, even after he found out, and I was grateful. She took a breath. I need the money from this inheritance. I really do. My marriage is struggling. My kids need things. I'm terrified all the time about finances. But if accepting the 2019 will means my siblings think I manipulated or lied or hid things, then maybe it's not worth it. Maybe some things cost more than money. She sat down, crying. The courtroom was silent. Judge Holloway reviewed her notes. Then she said something unexpected. I'm not going to rule today. I'm going to order a family mediation session. You three need to decide together what you think your father would want if he could see what this inheritance has done to you. I'll appoint a mediator, not Miss Porter, given her prior involvement, and you'll have 30 days to reach a consensus. If you can agree, I'll ratify that agreement. If you cannot, I'll make a ruling based on the law. But I can tell you now that the law doesn't always produce the right outcome in situations like this. She continued. Mr. Whitmore is correct that your father created an impossible situation, but you three don't have to compound it. You can choose differently than he did. The hearing was adjourned. The mediation was scheduled for September 15th with a court-appointed mediator named Dr. James Brennan, a psychologist specializing in family systems and estate conflicts. None of the siblings spoke to each other between the hearing and the mediation date. Sarah spent those weeks in therapy, processing her guilt over not knowing about Michael's trauma and her anger at her father for creating this situation. Michael returned to work but requested a transfer to a different project team. He told his manager he needed a fresh start. He didn't explain why. Jennifer and Mark began couples counseling. The counselor asked Mark about his gambling. Mark admitted he'd recently relapsed small amounts on sports betting apps. Nothing devastating yet, but the pattern was returning. Jennifer asked him to move out temporarily. He refused. They reached an uneasy stalemate. The mediation session took place in a conference room at a neutral location in Eugene. Dr. Brennan was in his 60s, calm and direct. He began by establishing ground rules. No interruptions, no personal attacks, honesty required. Then he asked each sibling to describe what they wanted from the inheritance. Beyond money, Sarah spoke first. I want to not feel like my father's love was conditional on my financial success. The original will gave me more because I'd managed better. That felt terrible, like I'd earned his approval by not needing him. But the second will feels like he was trying to erase that judgment, except he couldn't commit to it. I want to know that I mattered to him, not just as someone who performed well. Michael spoke second. I want nothing from him. I never wanted his money. I wanted him to see me and accept me, and he didn't. The inheritance is just a reminder that he could show up with money but not with honesty or courage. Jennifer spoke last. I want to not be the daughter who needed too much. I want to not be punished for staying home with my kids or for marrying someone who struggles. I want the inheritance to be a gift, not a statement about my worth or my choices. Dr. Brennan let them sit with those statements. 10. Ask it. What would happen if you walked away from all of it? Sarah looked startled. What do you mean? What if you donated the entire estate to charity? What if none of you took anything? What would that cost you? And what would it free you from? Michael answered immediately. It would free me completely. I don't need the money. I'd be fine. Jennifer hesitated. I can't afford that. My family genuinely needs it. Sarah said slowly. I could manage without it. It would be hard, but we'd survive. Dr. Brennan nodded. Then let's reframe. The question isn't which will to honor. The question is, what distribution would allow each of you to move forward without resentment, guilt, or obligation? They spent 3 hours working through scenarios. What if the estate was split equally, as the 2019 will suggested? But Jennifer agreed to set aside a portion in a trust specifically for her children's education, managed independently so Mark couldn't access it. What if Michael donated his portion to LGBTQ plus youth organizations in their father's name, making a statement about the support their father failed to provide? What if Sarah took a smaller percentage than either will allocate, using it only to eliminate her debt, and the remainder was divided between Jennifer and charitable causes? B or 4. They'd reached an exhausted consensus. The estate would be divided into 4 portions. 25% to Sarah, 35% to Jennifer, with 20% of her share placed in an irrevocable trust for her children's education, 15% to Michael, 25% to be donated equally to 3 charities, an LGBTQ plus youth organization, a scholarship fund for first-generation college students in their mother's name, and a hospice care organization. Michael's 15% would be immediately donated to causes of his choosing. He didn't want to keep any of it. Jennifer agreed to the trust arrangement. Mark was angry when she told him, but she held firm. Sarah agreed to take less than either will had allocated, finding a middle ground that felt more honest than either of her father's versions. The agreement was drafted, signed by all 3 siblings, and submitted to the court. Judge Holloway reviewed it on September 28th and issued her order. This court finds that the agreement reached by the parties reflects a thoughtful and mature resolution to a complex testamentary situation. While neither of the decedent's wills is honored precisely, the spirit of family consideration and equitable distribution is achieved. The court ratifies this agreement and orders the estate distributed accordingly. The case was closed. Act 5. The collapse. But closing the case didn't close the wounds. The checks were distributed in October 2022. Sarah used her portion exactly as she'd said, debt elimination and a modest amount set aside for Emily's future education. She felt relief, but also emptiness. The money solved immediate problems but didn't restore what had been lost. Jennifer received her portion in 2 parts, the lump sum and the trust for her children. She opened a separate bank account that only she could access and deposited the money there. She showed Mark the trust documents, but not the balance of her personal account. Mark's reaction to the trust arrangement became the final breaking point in their marriage. He felt humiliated, controlled, and cut out of family financial decisions. They had a massive fight in front of their children in late October. Ashley, their 16-year-old, recorded part of it on her phone because she thought documenting it might help them realize how bad things had gotten. Instead, Mark found the recording, accused Ashley of betrayal, and the situation deteriorated further. Jennifer asked Mark to leave in November. He moved in with his brother. They filed for separation in December. The divorce that followed was bitter. Mark tried to claim a portion of Jennifer's inheritance as marital property. Jennifer's attorney successfully argued that it was a separate gift, not subject to marital division, but the legal fees consumed nearly $40,000 of what Jennifer had received. By spring 2023, Jennifer was living alone with her 3 children in a house she could barely afford to maintain. The inheritance that was supposed to save her had instead precipitated the end of her marriage and exposed fault lines she'd been trying to ignore for years. She told Sarah once, in a rare phone conversation in March 2023, "I got the money, I'm still broke. And now I'm alone too. I don't know what I was fighting for." Michael followed through on his commitment. He donated his entire 15% to to organizations supporting LGBTQ+ youth, particularly those focused on college-age individuals dealing with family rejection. He made the donations anonymously, with one exception. He requested that one scholarship in their father's name include language acknowledging that mistakes in parenting can have lasting consequences, and this scholarship aims to support young people whose families didn't. The organization agreed. The scholarship was established. Michael never told his sisters about the specific language. He didn't need their validation, but the donation didn't bring the closure he'd hoped for. In January 2023, he began therapy for the first time. His therapist asked him why he'd waited so long. "Because I thought I was fine," Michael said. "I thought if I just didn't engage with my family, didn't need anyone, kept everything controlled, I'd be okay." "And are you okay?" Michael thought about the question. "No, I'm not. I've been not okay for 18 years. I just got very good at pretending." The inheritance hadn't caused his trauma, but it had forced him to face what he'd been carefully avoiding. That his father's rejection had shaped every relationship in his life, every choice, every wall he'd built. The therapy was painful. It took months before Michael could talk about the college incident without disorder. It took longer before he could begin to consider that maybe his father's failures didn't define his worth. Sarah struggled differently. The inheritance resolution had required her to be the mediator, the reasonable one, the person who found compromise. It was a role she'd played her entire life. But she was exhausted. In February 2023, she had a breakdown at work. A student came to her office crying about family pressure regarding college choices, and Sarah started crying too. She couldn't stop. Her principal sent her home and strongly suggested she'll take a leave of absence. Sarah took 3 weeks off. She spent the time gardening, reading, and avoiding thinking about her father. But the thoughts came anyway. She realized that she'd spent her whole life trying to earn her father's approval by being low maintenance, successful, capable, and he'd acknowledged it in the 2016 will by giving her more. But his acknowledgement had felt like judgment of Jennifer, and then his second will had felt like an apology for judging, which meant Sarah's success was just another thing he'd gotten wrong. She told her therapist, "I can't win. If I do well, I'm the good daughter who makes everyone else look bad. If I struggle, I'm a burden. There's no version where I'm just allowed to be human." The therapist asked what being human would look like. Sarah didn't have an answer. The 3 siblings had minimal contact through 2023. A few text messages on birthdays, a brief phone call at Christmas. But the depth of conversation never went beyond pleasantries. Jennifer sent a card to Michael in June 2023, apologizing again for not knowing what he'd been through and for not being a better sister. Michael texted back, I appreciate it." That was the extent of their reconciliation. Sarah tried to organize a lunch meeting in August 2023, suggesting they needed to talk about what had happened and figure out how to move forward. Michael declined politely. Jennifer said she wasn't ready. The family had survived the inheritance dispute. "Then why don't you call them?" "Because I don't know what to say," Emily, with the clarity of youth, said. "Maybe start with, I miss you." Sarah took her daughter's advice. She sent a text to the sibling group chat in November 2023. "I miss you both. I know everything is complicated, but you're my brother and sister, and I don't want to lose you over money and Dad's mistakes. Can we try?" Jennifer responded within an hour. "I miss you too." Michael took 3 days to respond. "I'm not ready yet, but I appreciate you saying it." It wasn't reconciliation, but it was a thread, thin and fragile, that suggested reconciliation might someday be possible. Act 6. The aftermath. It's now September 2024. Nearly 3 years since Robert Whitmore died. The commercial building in downtown Eugenie sold in January 2024 for $810,000. The proceeds were distributed according to the agreement. Portions to each sibling, portions to charity. The final checks arrived in February. Sarah used her final payment to take her family on a vacation to Italy. She and David had talked about for years but never felt they could afford. They spent 2 weeks traveling, eating, wandering through museums and old cities. Emily loved it. David relaxed for the first time in months. Sarah felt something she hadn't felt in years. Lightness. On their last night in Rome, Sarah stood on a terrace overlooking the city and thought about her father. She tried to imagine him there, seeing Beatty, experiencing joy. She couldn't. All she could picture was him alone in his house in Eugene, drinking scotch, reading books he'd already read, thinking about children he didn't know how to talk to. She felt sad for him. Not forgiveness, exactly, but sadness. For a life constrained by inability to connect, Jennifer's divorce finalized in April 2024. She received primary custody of the children. Mark received supervised visitation due to concerns about his gambling and emotional instability. Jennifer kept the house. With what remained of her inheritance after legal fees and debt payments, Jennifer went back to school. Online nursing program, part-time, with the goal of returning to work once her youngest started high school in 2 years. She was 47. But they hadn't survived as a family. In October 2023, Emily, Sarah's daughter, now 15, asked her mother. Well, they never saw Uncle Michael or Aunt Jennifer anymore. Sarah struggled to answer. Things got complicated with Grandpa's estate. Sometimes money changes relationships. Did you guys fight? Not exactly. We learned things about each other and about Grandpa that were hard to deal with. Do you miss them? Sarah realized she was crying. Yes, habido. Starting over felt terrifying and liberating in equal measure. Her daughter Ashley asked her in May 2024 if she regretted the way things had turned out. Jennifer thought carefully. I regret that the money came with so much pain. I regret that your dad and I couldn't make it work, but I don't regret that I finally stood up for myself and my kids. The inheritance didn't save me. It just gave me the space to save myself. Michael remains in Seattle. He's still in therapy, working through layers of pain that the inheritance dispute forced to the surface. In March 2024, he started dating a software engineer named Daniel for the first time in 6 years. The relationship is tentative, careful, but Daniel is patient with Michael's walls, and Michael is trying to learn how to let someone in. In July 2024, Michael drove to Eugene for the first time since his father's funeral. He didn't tell anyone he was coming. He visited the cemetery, stood at his father's grave, and tried to find words. What he finally said was, "You were afraid of the wrong things. You were afraid of hard conversations, of admitting mistakes, of being vulnerable. You should have been afraid of dying without ever really knowing your children." That's what actually happened, and it was preventable. He stood there for 20 minutes, then left. On the drive back to Seattle, he called Sarah. They talked for the first time in months. Really, tal. Really tal. About therapy, about healing, about whether forgiveness is necessary or just another expectation they're supposed to meet. I don't think I'll ever forgive him, Michael said, but I'm trying to forgive myself for needing him and for being hurt that he failed me. That seems fair, Sarah said. In September 2024, Sarah organized a lunch meeting. She didn't call it a reconciliation. She just invited Michael and Jennifer to meet her in Eugene. Neutral territory, no expectations. You were doing the best you could with what you had, Michael said. I'm sorry I shut you both out. You weren't the ones who hurt me, but you got caught in the blast radius. They cried. All three of them, in a restaurant, not caring who saw. It wasn't healing. It was the beginning of the possibility of healing. They made plans to meet again in 2 months. Then they revised it to 1 month. They created a group chat and actually used it occasionally. They sent photos of their kids, their lives, small moments that didn't require analysis or apology. Sarah told her therapist in late September, I think we might be okay. Not today, not for a while. But eventually, the question of which will was right never got answered. Judge Holloway's ruling essentially declared both wills inadequate and replaced them with something the siblings created themselves. Robert's intentions remained ambiguous. Was the 2016 will this true desire mathematical fairness accounting for previous gifts? Or was the 2019 Wilda's final stance equality, despite different needs and circumstances? The truth is probably neither. Robert's true intention was to avoid confrontation, to make decisions without facing consequences, to fix relationships without doing the emotional work. Both wills were evidence of the same pattern. Good intentions, inadequate follow-through, a belief that money could substitute for honesty. The inheritance divided the family, but what destroyed it wasn't the money, it was the secrets, the judgments, the failure to communicate that had been building for decades. Robert died believing he could solve this from beyond the grave with carefully worded documents. But documents can't substitute for conversations. Legal language can't replace emotional truth. What the second will revealed wasn't just competing financial interests. It revealed a family that had been fracturing slowly for years, held together by obligation and routine rather than genuine connection. The inheritance didn't break them. It just exposed breaks that were already there. Sarah, Michael, and Jennifer lost approximately 18 months to fighting over their father's estate. They spent tens of thousands of dollars on attorneys. Michael said yes. Jennifer said yes. They met at a small restaurant downtown on a Saturday afternoon. The conversation was awkward at first. They talked about Emily's college plans, Jennifer's nursing program, Michael's relationship with Daniel, surface topics, safe terrain. Then Jennifer said, "I'm sorry I made everything about money. I was desperate, and I let that desperation make me suspicious of both of you." Sarah said, "I'm sorry, I acted like your need was somehow a moral failing." They uncovered painful truths about their father and themselves. They damaged relationships that may never fully recover, but they also learned something their father never did. That healing requires honesty, even when honesty is uncomfortable. That forgiveness isn't mandatory, but clarity is necessary. That family can be rebuilt, slowly and imperfectly, if everyone is willing to show up without armor. The estate is settled. The checks have cleared. The properties are sold. The charities have their donations. The lawyers have their fees. What remains is more complicated than any will could address. Michael keeps his father's last letter in a drawer in his Seattle condo. He doesn't read it often, but he doesn't throw it away either. It's a reminder of what happens when people wait too long to say what matters. Jennifer has her children's trust fund statements filed carefully in her home office. She looks at them sometimes and thinks about the difference between what she needed and what she received, and how those things weren't the same, but both were true. Sarah has a photograph of the 3 siblings from 2010, before everything fell apart. They're at a family wedding, smiling, standing close together. She keeps it on her desk at school. Students sometimes ask who they are. Sarah says, "That's my brother and sister. We don't see each other as much as we should, but we're working on it." The inheritance gave them money. It cost them years. Whether that trade was worth it is a question none of them can answer. But they're still here, still trying, still believing that maybe, eventually, they can build something better than what their father left behind. That might be the only inheritance that matters.